major malfunction. Didn't Mommy and Daddy show you enough attention when you were a child?
Let's play this backwards and see if it gets any better.
Let's get down to business. What do you say?
Show me the money!
Always be closing. Always be closing.
You're now listening to Boots to Business with Daniel Hrabowski.
And welcome everybody to Boots to Business. My name is Daniel Hrabowski. You can hear us every Sunday from 5 to 6 on WFLA Orlando at FM 93.1, 94.1, or 107.7. You can find us online at all of the socials or at our website at www.boots-to-business.com. First part of the show is brought to you by the Insurance Claims HQ, powered by the Harris Shannara Trial Attorneys. Their commitment is to help make you whole again after a disaster. Call 844-252-4684. Visit them at insuranceclaimhq.com. In the studio with me today, as always, and my new staple co-host is Melissa Jacob with Striking Brand. Hi, Melissa.
Hello, hello.
And our guest today is Dahlene Miller with...
Desmond and Dover. Oh, you're going to have to say it closer.
Oh, we're going to have to say it again.
Right
Come
on
in
into that mic.
a little bit further. Say it again.
Demesman and Dover.
Demesman and Dover. There we go. So Dahlene is a first party or third party? Or both?
Both.
Okay, so Dahlene does first party and third party insurance claims for property insurance in particular. For our listeners, can you give an easy, lamest version of the difference between a first party and third party claim?
Sure. So a first party claim is basically the individual that has the rights under a homeowner's insurance policy or a commercial policy.
Okay.
Whereas a third party is any entity that would sign a contract. So that would be your contractors, your dry out companies, any of those individuals that are doing work on your behalf that are part of that claim against the insurance company.
So like a subrogation lawsuit or something like that would be considered a third party. So if I'm subrogating against a contractor who damaged my property, would that be a third party claim at that point? Because we see that a lot here, where contractors come in and they're doing work for insurance proceeds against a claim, and maybe not exactly how they're billing for those things, but and then the contractor damages something, the carrier then has to subrogate against the contractor or the contractor's insurance company. Is that something that is a third party claim?
A third party is essentially the ability of any of those contractors to stand in the shoes of the homeowner and go against the insurance company directly for the services that they perform to make the home restored back to the way it was before the loss.
Gotcha. Okay. That makes more sense. So, and you are a partner at your firm.
I am.
And how many partners do you guys have?
We have 4.
There's 4 partners. So as far as law firms go, at what point, and this is kind of a jovial question, at what point do you stop adding names to the, because some of these, you go into like New Orleans, you go to New York, you'll see there's like 6 or 7 names just.
Oh, yeah.
So what, is there like a general rule when it comes to law firms that you go, you know what, I'm going to stop adding names at the end of this?
Yeah, there's a structure out essentially, but there's the name partners where you have all of those 2 to 6, 8 names. Then you have the equity partners, which are the individuals that actually have shareholder rights to the firm, and then you have just title partners, which are just the entities that are involved for like running the corporation.
Oh, now we have our entire first segment. I have all sorts of questions. So how do you become a title partner as opposed to, is it you start at the bottom of just like a named partner and then you get to be an equity partner and then you get to be a named partner? How do you guys determine who gets to be which of those?
Every firm is different. So it really does depend. I mean, you could just go off on your own and make yourself the named partner.
Love that.
Or you could enter a firm and through the value that you've brought to the company, they can see, you know, this is somebody that we would like to have as a title partner that would essentially be running the department. Whereas if you are an equity partner, it's more so a structure where you're helping the firm develop as a whole. So you're overseeing a lot of different departments.
Okay, so there is a requirement for the description of what you're doing. So if you're an equity partner, then it's almost like being a C-suite type of person, right? Where if you're in a C level in a company, then you're not necessarily dealing with the individual items anymore. You're dealing with the business development, the professional growth of the people working for the firm and that kind of stuff. So the equity partners are there, and then the name partners are more of the like board of directors type of thing. Okay.
Correct.
And then do you guys stick to just like one or two general, because one of your partners is an injury lawyer. So what do you guys have in your firm? You have the third and first party litigators.
Yes. So we have our homeowners insurance claim department, which is the first and third party.
Okay.
Then we have the bodily injury department, which is all of your car accidents that you see the advertisements for. Then we have the PIP division. Then we also have now just added a criminal division, a TCPA division, and a workers' compensation.
Oh, nice.
Oh, wow. So with all of that being said, so you guys are paying attention to a lot of statute changes in the last few special sessions, specifically here in Florida. And are you guys barred in any other states, or you guys practice just in Florida?
Right now we just practice in Florida, but we are looking to expand.
Okay. I could see that. So, but you guys in the legal side of things, and I've spent my fair share in the last 48 hours talking to law firms. It's been inundating. It's always interesting to see how some of the different statutes exist in different states. I was having a conversation this morning about with a lawyer from Oklahoma talking about Texas statutes. And we were talking specifically about how agency exists and somebody acting under the agency of somebody else. So they were talking about, is it ad hocing or pro hocing into another state? If you're working under somebody else's license, you're being pro hocked in. Is that the right term?
Yes.
So that's just essentially just acting under somebody else's license in that state because we like you and we want you to represent us, but we're in Georgia. So you can do that. Is that a cumbersome process? Is it something that's kind of a one and done, case by case basis type of thing?
I wouldn't really be able to speak much on that because I haven't myself dove into it, but practicing in Florida, we really don't have reciprocity in other states, as opposed to other states where if you get barred in that certain state, you have the right to practice in several other states.
Oh, see, I didn't see it. I didn't think it worked like that for lawyers. I thought you guys had to license in every state that you guys wanted to practice, and I didn't realize there was any of that.
I think I heard that that's usually the case, actually, that they have reciprocity, that there are fewer states that don't, like California, I think, might be one.
Yeah, California does not, Florida does not, Texas does not, but other states, like let's say Michigan, right? Like they'll have reciprocity with several other states that if you get licensed in Michigan, then you can also practice in several other states.
So it's like that for us in the PA licenses as well. Like if you are a resident license holder for a PA license in Florida, they don't reciprocate with anybody, but Florida doesn't. But other states will accept Florida. So there's like a half reciprocity there. It's kind of a weird thing. But same thing with general contracting laws. So I guess it makes sense. I just didn't realize that for law firms you had to, or individual lawyers you had to, or that you could reciprocate. I thought you just had to, every time you wanted to go into a new state, you needed to pass. Because now do you have to pass the bar for in each state?
Yeah,
and they're all different?
And they're all different, and they're all different amounts of time frames, different laws. You have to relearn, again, all the federal laws on top of the state laws if you'd like to change.
That seems like a lot to keep track of, too. Like if you're practicing in multiple states. It's like, yep.
But you get to bill for your time to go back and dig, right?
Not at all.
What? Huh.
No.
Well, maybe I picked
It's about a 3-month course of studying that you have to do.
What I meant was like if you went and got your license in Tennessee, and then you don't necessarily need to know all the time what's going on in Tennessee until somebody hires you to do something, and then you get paid by them to make sure all that stuff is.
Oh yeah, absolutely.
Yeah, because it's kind of like being a doctor, right? Like you're not always going to treat knees, right? So you need to know how to do it, but that's not exclusively what you're going to do all the time.
Yeah.
Well, see, I'm learning all sorts of things about being a lawyer today. This is great. I'm glad that California doesn't reciprocate with anybody because, what's her name? Kim Kardashian passed what's the baby bar? What's the baby bar?
Well, interestingly enough, California is the only state that you do not have to go to law school and you can just take the bar exam and become a lawyer.
No, interesting. See, I always thought to myself, what if I was just smart enough to just happen to pass the bar? Could I become a lawyer?
In California.
Apparently in California you can, and I feel like I'm really missing the boat here. Maybe I need to move to California. We're going to go to a break. We'll follow up on some state-specific statutes and stuff when we come back. This is Boots to Business. My name is Daniel Rabowski, and you can listen to us on WFLA Orlando every Sunday from 5 to 6 p.m.
We now return to Boots to Business with Daniel Rabowski.
And welcome back to Boots to Business. My name is Daniel Rabowski. This portion of today's show is brought to you by Shield Tech Roofing Solutions, your premier destination for commercial roofing excellence. When it comes to protecting your commercial property, trust in their top-tier roof coatings and expert repair services. Their commitment is unparalleled customer service and roofing expertise to ensure your satisfaction. Explore their specialized solutions for commercial roofs today at shieldtechroofing.com and choose Shield Tech for lasting high-quality commercial roofing solutions. That's a long one. In the studio with me today is Melissa Jacob from Striking Brand.
Hello.
And Dahlene Miller from
Demesman and Dover.
I'm just going to have her say it all show long because I will screw it up. So before the break, we were kind of getting a good rundown of what it takes to be a lawyer. At least in California, we could all go do it.
If you're smart enough.
But I wanted to spend some time in this section talking about Florida statute changes, because there's been a lot of them this year that are going to affect next year. And with a lot of the Ian claims coming up in the statute or the statutory guidelines for, whatever needing to happen is kind of expiring now, right?
Yes. They've already expired for Ian, but not right. Hurricane Nicole.
Nicole's still left, yeah. Mm-hmm. So what does that mean for homeowners and property owners to have that statute of limitations expire? Because I know for us, there's a fee change, right? We are no longer capped at 10%. Now we can go back to our original 20, which again, being out of Texas, we're always capped at 10. So going into a state where they do 10, 20, or 15, 20, 25 is the craziest stuff in the world to me. How does that affect it? One, from the consumer's perspective, and then two, from a law firm's perspective.
So from the consumer perspective, the law changed, and now from the date of the storm, you have 1 year to report that claim. After that year has passed, you can no longer report it to the insurance claim, and you will not be able to recover anything under your policy.
So is that a filed a suit or filing the claim in general?
Filing the claim in general with your insurance company.
Wow, because we do see a lot of filed a suit language, which doesn't necessarily negate your ability to file a claim. Mm-hmm. It just, you hope that your carrier is going to be reasonable, because you can't take them to court. Mm-hmm. You can't go to litigation with a filed a suit clause. But you're saying that they can't even file a claim after that.
No. And what's interesting is when I started practicing, you used to have 5 years to file a claim with your insurance company for damages. Mm-hmm. Then it got down to 3 years, and then 2. And then last year they made it 1 year for reporting the claim to your insurance company.
Now, does that change if there's a disaster declaration, like another Hurricane Ian, right? If a Cat 2 or more comes through and the state declares an emergency, does that change at all, or does that statute exist regardless?
So that statute exists regardless, but let's say you were in the area where you had been hit by Hurricane Ian, and then came along Hurricane Nicole.
Right.
And also hit your home. Mm-hmm. That would be, depending on what areas of the home were damaged, it could be considered what's called a supplemental claim. So those are additional damages that have occurred with an already open claim. And the deadline under the statute of limitations for that is now 18 months. So a little bit over a year.
So what if they didn't file an Ian claim, and then Nicole came through a month later, right? And they filed it. The homeowner's not going to be able to delineate what damage was related to Ian and what damage is related to Nicole. So what does the statute say regarding that?
As long as they get both of those claims into the insurance company, really the fiduciary duty is on the insurance company to really figure out which of those 2 storms was the damage. The homeowner just has the onus of reporting it to the carrier and making sure that within 1 year of last year's September 28th, 2022, for Ian, it was reported.
Okay. I love that word onus, by the way. One of my favorite words. I dealt with this a lot when the derechos hit Iowa, 3 years ago, because the derecho wiped out a third of the stuff in the state. I mean, I think I saw something that said like a third of the nation's corn crops come out of Iowa, and they were destroyed. My numbers could be wrong. Somebody will see this online and fact check the crap out of me, but it's fine. But while we were working the derecho claims, this massive hailstorm came through and dropped like 3.5-inch hail on all these buildings that had already been smoked by the derecho. And so we were running simultaneous claims because the carriers wanted to be able to separate what was the derecho claims and what were the hail claims. And even though it was the same building, And then we started getting into the minutia, right? Of like, well, is this a debris strike or was this hail? And it was such a pain in the butt. So while I can appreciate the supplemental claim idea, it's not ever easy, right? And this is why claim representation is so important, because again, it's almost like being a mechanic and your dad taught you how to change your oil, but that's all he ever did. Like, I'm going to call a mechanic to fix my car at that point. And nobody expects a homeowner to understand how their house was built. Nobody would, with a reasonable expectation anyway, assume that they understand the means and methods, building codes, material variances, like all of these things. But yet we're leaving so many Floridians out to dry because they got smoked by 2 hurricanes back to back, and the carrier's trying to live in this semantics argument all the time, right?
Yeah, absolutely. And that's kind of the issue that the homeowners themselves run into, because when you report the claim to the insurance company, we see this all the time where they will put the date of loss as the date the client reported the claim to the insurance company, even though the storm occurred a month ago. You know, the client doesn't know that. They're just calling in and saying, I see water entering through my home. And so they put that as the date of loss. And then when their forensic weather experts go in and look at the weather data and say, oh, well, there's no wind on this date.
Right. Well, and sometimes that can work to their advantage, because data discovery is important for certain perils. And again, being a property owner, Melissa, do you know what coverage D on your insurance policy is?
Coverage D, no, not a chance.
No, neither do I, and I deal with policies every day. But point is that it's one of those things, like, if I know where to look for it, and I live in that space, there's no way most homeowners are going to have the slightest, and even property owners, let's say you live in California and own a building in Orlando. Most of these folks are going to have no clue where to even start in their policy, let alone understand how the verbiage is written, let alone be able to interpret that, and then make an argument on their own behalf. Because even bringing in a claim representative, the person with the most power in that entire process is you. The policy holder has the most power, but the least knowledge, right? And so you have to bring in people like Dahlene, you have to bring in people like me, and a handful of other people that are really good in that space. But it's hard for them to keep up with all these statute changes. And the statute changes don't just affect insurance policies, they affect contractors and what contractors have to do in reporting requirements and some other things like that, right? Like, it's not just exclusive to the policyholder.
No, it's not just exclusive to the policyholder. And put alongside that then the pressure of people knocking on your door and telling you that they can resolve this, and having individuals like roofing companies coming in and trying to interpret policies, when under the state of Florida law, only public adjusters and attorneys are allowed to interpret the policies on behalf of the homeowner and advise them, because there's a slew of language, if you get a full copy actually of your policy, that outline post-loss obligations. And the scary part is that there is language in there, like one of the new languages I've seen with Progressive, for example, states that immediately when you report a claim, you have 60 days to provide them with a sworn proof of loss.
So let's live there for a second. So what's required in an SPOL?
So what's required in a sworn SPOL, which stands for the sworn proof of loss, is essentially an outline to the insurance company, and they would like for you to use their forms that basically outlines to them what is the property that is being claimed, the entities involved, what are the damages associated to that claim, the policy limitations that are in your policy, and then they have a breakdown between coverages A through D. So coverage A would be for your dwelling. Coverage B would be your other structures. That would be anything like your lanai, your pool, the fence areas, things of that nature. Coverage C is all of your personal contents. So that would include your electronics, your clothing, anything within the dwelling that is not really attached to the dwelling itself. And then coverage D is anything from additional living expenses. So let's say you had to flee from a hurricane, those expenses associated with having to stay at a hotel or a temporary Airbnb if you're having work done to your home, or if this is a vacation home for you and you live in California, those monies that would have lost for the loss of rental income.
Yeah, and I want to live there when we come back, because there are some things in here that are still, they're ambiguous, right? And ambiguity is supposed to always err to the side of the insured in every policy in the country. And a lot of times, unfortunately, it doesn't. So we'll be back here in just a few minutes. This is Boost to Business. My name is Daniel Rabowski. See y'all in a few.
We now return to Boots to Business with Daniel Hrabowski.
And welcome back to Boots to Business. My name is Daniel Hrabowski. This portion of the show is brought to you by Golden Temple Builders. No tongue twister that time. Bringing decades of expertise to commercial renovations and remodels, their commitment to you is clear written pricing options tailored specifically to your project. Visit them at goldenTempleBuilders.com for details or call them at 321-508-0815 and let them help you build your vision together, serving Florida, Texas, and Louisiana, and Costa Rica, in case anybody wanted to know that. In studio with me is Melissa Jacob with Striking Brand.
Hello, hello.
And Dahlene Miller with
Mesman and Dover.
Yes.
Mesman and
All right. So before the break, we were talking about sworn proof of loss and the 60-day requirement. And most policyholders are not going to understand the magnitude of what that means. So especially your contractor, if you bring in a PA, if your law firm, we all have to adhere to that statute change. But so does the carrier. So we have 60 days to write an estimate, prepare the documentation for the loss, and submit an SPOL. They have a time frame to respond to that with the new statute change, correct? If I remember, what is that time frame? I don't remember what it is off the top of my head.
To respond with a sworn proof of loss being submitted?
Yes.
I believe it's 7 days.
They have 7 days. So, but the carriers never meet these statutes. And that's the frustrating part when you're a homeowner or property owner and you don't have any representation. Mm-hmm. You're doing the things that you feel like you're supposed to do, and then the carrier goes, "Well, I know it was 7 days, but 21 days later, because of our current workload, we'll get to you." And that stuff, we see it all the time. The problem is they can hold us accountable massively. Mm-hmm. They can file complaints with DFS. They can go after our licenses. They can do all these things. We can shoot back up that hill all day long, and they just go, "Okay, that's fine," and keep doing what they're doing. So we're kind of in this weird space where we're always forced to make sure we're living between the yellow lines, knowing that they're not. Mm-hmm. And when you talk about things specifically like duties after the loss, you have a responsibility to mitigate further damages. What does that mean to you? If I say, hey, if your house gets hit by a tornado, you have a duty. You have a duty to mitigate further damage to your property.
Try to keep it from happening again or making it worse.
Mm-hmm. Are you a carpenter?
Yeah.
Are you a roofer? Are you a
I'll
plumber?
throw some towels on my door.
So then there's that's the ambiguity that we're talking about is what is a reasonable expectation for a 20-year-old kid who's going to college who has to mitigate further damages on his house, or a 95-year-old lady who can't barely get out of the house on her own. She's got to mitigate further. So it's a very open-ended thing, and that's the struggle, right?
It is a struggle, but with good documentation, you could actually get the carriers to be on the hook for bad faith. You would have to take it all the way to a jury and get an award by a judgment. But outlining those things early on from the very beginning and showing under the statutes, if one of the statutes that's really important on this measure is that if they had the ability to afford coverage and they didn't, that right there is bad faith.
And they have a timeline for that too in the new statute, right?
Correct. It used to be 90 days that they had to investigate unless there were exigent circumstances, and then they would require to advise you of such exigent circumstances. Now it's been limited to the 60 days.
Right. And only the governor can trump that, correct? Or DFS or the insurance commissioner can extend that, correct?
Yeah, only the insurance commissioner.
Under certain circumstances.
Under certain circumstances, like a state of emergency, things of that nature.
Yeah, and that's massively important. But again, and there's a fee difference for everything that we do. And most lawyers are successful, at least in my experience, are successful in dealing with claims at that magnitude because the bad faith statutes exist. It allows them to take some of the burden off the homeowner and handle certain things by very easily saying, your carrier was obligated to do these things, and then they didn't. So because of that, now you are not properly indemnified. You are having to have additional living expenses. You're having to not live in your home. You're having to deal with things that you should not have been able to deal with or should not have to have dealt with because your carrier didn't do the right thing. So when we talk, there's a difference, and I think for anybody listening, there's a big, big difference between hiring a public adjuster, hiring a law firm to handle your claim, and hiring a law firm to handle your bad faith claim, right? You would agree?
Yeah, but we can't get to the bad faith until we get that jury verdict too. So you would have to get the lawsuit in place, and it would have to be all the way brought to a jury. And then once they've rendered a verdict, then you can go after the bad faith. So the insurance companies kind of know that, because if you reach a settlement well after you filed the complaint, you've essentially foregone your ability to go after the bad faith. And that's how they hook it, because they put it in the release language so that you cannot go after them for having delayed your claim for months and months on end, and all of the bad things that have occurred since that time frame of processing the claim on your behalf. And so they know that dragging it out through the court systems, a lot of homeowners, they get tired. This is not the criminal case, where you can have 90 days right to a jury. In the civil world, you have essentially 12 months to 18 months. And that's if you have a very proactive attorney on your behalf that's demanding trial from the onset.
And that's assuming that law firm hasn't been overloaded and inundated with thousands of claims like every other law firm in after a major hurricane or anything like that. But one of the things that we see a lot because Nicole was my 12th, I think it was my 12th hurricane that I've worked, and contractors will go in and they'll try the first time to get a roof bought or a building bought or mitigation covered or whatever, and the carrier comes back and undervalues it. And then you'll hear these contractors say, oh, well, your carrier's acting in bad faith. You will never hear a good public adjuster say the term bad faith. I'm not a lawyer, I'm not using it. And lawyers will only use it in its appropriate context unless they're crappy lawyers. But contractors will use that to try and leverage homeowners into, and it's almost this weird duress, right? And they're not working in a capacity to be able to identify that. Most of the time when that conversation is being had, it's because they didn't get their way. Well, I said it was $10 and they only said it's worth $2. Well, that's not necessarily acting in bad faith. That's mitigating risk. Like those are two different things. But with a lot of these statute changes, the contractor side is being held a little bit more accountable. And in very broad brush strokes, I think we can kind of dive down that road. They have to, if I remember correctly, they have to very specifically, that there's different contract language they have to put in there, and then they have to show very clearly what they're charging, correct?
Correct. They have to have certain language within their contracts that outline that this is, in fact, for an insurance policy. And then they also have to include a breakdown of what those costs will be associated with the bid. They cannot just give a description of what that will be without putting in the units, the square footage, the price, all of that, which is a common issue that we had seen. And now the changes have affected us even more, because we used to have a contract called an assignment of benefits. That assignment of benefits is no longer in place. Now the only way that you can actually have any kind of company come in and do work without being paid on the front end would be signing a contract called a direction to pay.
Yep. So let's live at AOBs for 2 seconds, because we're using a lot of terms here. So assignment of benefits, and the reason a lot of states got rid of them is because the contractor base was using AOBs to absorb the property. Because let's say you had a $50,000 deductible on your property, but you didn't have the $50,000, you could waive your deductible and assign the benefit of your claim to the contractor, and they would acquire real estate this way. Go to Tennessee, just look up just random, board on a Tuesday, just Google AOBs in Tennessee. There were a handful of contractors that were the cause of a lot of other states getting rid of assignment of benefits, because they were, I don't want to say they were acting unethically, but they knew what they were doing, right? And they were kind of going, well, this big high-rise commercial building, you don't have the $200,000 deductible. That sucks. Just assign the benefit of the claim to me. And now, obviously, it's way more complex than the way I'm saying it, but they were starting to absorb real estate that way. And finally, some people started going, hold on, I think I got screwed here. And so Florida got rid of AOBs, which sent the contractor world into a tizzy. Because they couldn't leverage that anymore. However, at its core, at least in my belief, an AOB's intention is no different than a direction to pay is. It's just saying, I'm going to do the work, and I'm going to get paid for the work by your carrier, not by you. So we'll live there a little bit here after the next break. This will be the last segment of the show. My name is Daniel Rabowski. You're listening to Boots to Business. We'll see y'all in a few.
We now return to Boots to Business with Daniel Hrabowski.
And welcome back to Boots to Business. My name is Daniel Hrabowski. This portion of today's show is brought to you by Coastal Claims Services, your trusted partner in public insurance adjusting. They're headquartered here in New Smyrna Beach, Florida, serving clients nationwide. They specialize in residential roof claims and commercial property claims when it comes to protecting your home or your property and ensuring that you receive fair insurance compensation. Count on their experienced team of public adjusters. Explore their comprehensive services today at coastalclaims.net and let Coastal Claims Services be your advocate for a hassle-free roof claim or property claim. In studio with me today is Melissa Jacob.
Hello, hello.
Dahlene Miller.
Hello.
And we have been talking today a lot about Florida statute changes and what that looks like when we're talking about property insurance claims. And I know there's some things that you want to make sure that we really have an opportunity to drive home. One of those being the difference between an AOB and direction to pay, clarifying a couple things we went over earlier just before we all get our heads chopped off by the internet, and just kind of some things to kind of prep while we are still technically in hurricane season. We could get a late season one, and so there's some things that Dahlene has spent a ton of time researching and reviewing and going through different statute changes to make sure she understands it. So when we have these conversations, she can leave people feeling good about it. So let's start with AOBs, or actually let's start with the SPOL clarification, and then dive off into whatever direction you want to.
Okay, so there is a new statute that basically outlines that from the date that the insurance companies do receive that sworn proof of loss, they have 14 days of receiving that proof of loss to begin the investigation of the claim. So the original language of the statute required 90 days, went to 60 days for them to investigate and make a determination. One of the ways you can hone them in quicker is giving them a sworn proof of loss from the moment you report that claim, because then under this statute, they have 14 days to begin that investigation.
And that's massively important, especially when we talk about the public adjusting side, because a lot of PAs and came out of the contracting space, so they're familiar with how to do cost analysis, estimating, and things like that. So the faster that your public adjuster, if they're the ones that you decide to go with, the faster that you can get that information and they can produce a dollar amount associated with your loss. And again, it's not that has to be the soup to nuts. It can be changed later. That you can do supplemental things, but the faster that they can get it, the faster you can require your carrier to come back around and be responsive.
Yeah, and then another way that the homeowners actually can help the public adjusters or any advocates working on their behalf under one of the new statutes as well is that if the homeowner reaches out and advises the carrier that they would like a copy of any of the findings from the insurance company's adjuster, the individual that went out on the insurance company's behalf and investigated, that homeowner has the right to receive that under the statute now within 7 days.
The original.
And
that's important because there's a new, that's going to be the first set of case law, I would assume. I'll breeze over this because she's got a lot that I want her to be able to get to. But basically the desk adjuster, so you have a field adjuster and a desk adjuster. The field adjuster goes out and does all the stuff, sends it back, a desk adjuster makes the assessment and finalizes things. Very broad strokes. But somebody got in trouble because the desk adjusters were altering the field adjusters' estimates and scopes of loss without informing them and leaving all of their information on there and to the benefit of the carrier. So that's why it's important that you can ask for the original because then you can see if there's any discrepancies.
Got it. That makes sense.
And a lot of times, too, we will, even as the attorneys working and reporting these claims on behalf of the homeowners, they will refuse to provide us sometimes with the field adjuster's photos or the estimates until we actually get into a lawsuit with them and subpoena those documents because they claim them as privileged.
Or engineer reports are the big one for us on the PA side. We'll ask for the original copy because a lot of engineers, if an engineer does what they're supposed to do, they're called out to be unbiased and just identify the scope of damage and causation sometimes, depending on what the engineer is being called out for. They're not to determine coverage. They're not to determine dollar amounts for coverage. They're not supposed to do any of that. But a lot of times you'll find little verbiage in those engineer reports that prevent or that are to the benefit of the insured. And by the time it's produced to the insured, it's modified and or pieces are missing, or you only get page 1 and 3, but not page 2. And it's a cat and mouse game all the time.
All the time.
When they refuse to give you those, doesn't that just feel like, oh, you're definitely hiding something?
Oh, absolutely. Yeah. But they always claim it as they're still in the process of the investigation, and they can hide behind that investigation process because ultimately they can say, well, we we feel that whoever we hired on our behalf, whether it be an engineer or a field adjuster, was not postured to identify the damages that really took place in this. So we would like another bite at that apple. And that's really what they're doing, is when they're saying those kinds of things, it's more so they're gearing up for trial, because they want the kind of individuals, whether it's a field adjuster or an engineer, that's going to be best postured to represent the insurance company in front of a jury panel.
Got it.
Yep, and that's the start. Where do you start to see those things? When you see the carriers start to balk, that is the start of the bad faith type conversation. Doesn't mean that it goes that route, but those are those identifiers that you want to start paying attention to for sure.
Absolutely.
Was there anything else as far as statute changes that you wanted to kind of touch on very briefly?
Yeah.
I know that, like I said, you'd be surprised how fast these segments go by. So
Yeah.
I will make the floor yours.
Just for all of our homeowners in Florida, we do have a wonderful program that was enacted through the statutes. It's called the My Safe Florida Home Program. It's basically awarded $150 million between this year and next year, in which homeowners can get matched by the state for every $1 that is spent. The state has agreed that they will match it for $2 up to $20,000, so essentially $10,000.
And what's that get them? Like, as far as not necessarily from a monetary perspective, to spend on what?
So that is used to spend on any way that they are going to prevent the home from any windstorm damage. So that could be your impact doors and windows, that can be your roof, that can be structural work that is done to prevent the home from suffering wind damage, as an effort from the state to try and prevent more of these insurance claims from going forward.
No, and that's fantastic. And it's great. It's good when you see those things be implemented, but then if they get overused, FIGA is a good example. When they get overused, so FIGA is the Florida Insurance Guarantee Association, right?
Correct.
And the idea is that they're going out on a limb saying, we'll guarantee that you'll always have money. The carriers will never be insolvent. They'll never run out. We've seen 3 or 4 go insolvent with this storm, and FIGA be so massively overloaded that it takes months to get an adjuster assigned through FIGA.
Yeah.
So hopefully that we don't run into the same thing with this type of thing. It's more of just a dollar exchange, not necessarily somebody having to be assigned as an adjuster. It's almost a co-insurance thing, FIGA, which I don't care for, but
Yeah, FIGA is, but they do have their selection of vendors that you have to choose from. So it cannot be that they're going to match $1 and give you $2, but it has to be under their people. You can't just select your own.
Okay.
I'm a big fan of constraints when used properly. Like, if you put confines on things and you can say, if you do these 10 steps, everything will be fine. I'm a huge fan of that, because it reduces conflict. It reduces discretionary decisions, I think, a lot of times. And when you're talking about how many people end up being involved in a property insurance claim by the time it's said and done, I mean, even if it just went to a PA, from a PA to a law firm to go to litigation, you're talking at least one PA, at least one lawyer, their paralegal, somebody else in their office, and then not to mention the 20 people on the carrier side. So you get so many hands in that pot, it can get complicated very, very quickly.
Very, very quickly. Not to mention forensic weather experts, engineers, all of those things. And going back into the AOB versus direction of pay, that we were discussing, the assignment of benefits would essentially allow any contractor that was working to restore the home back to its pre-loss condition to step into the shoes of that homeowner and then make a claim on behalf of that homeowner to obtain all of the funds for the work that they had performed. So you had a storm damage and they came out with a dry out company and dried out all of your home. Instead of seeking the money from the insurance company, they could go directly there.
Nice.
And the homeowner wasn't allowed to obtain any monies from that claim.
And the direction to pay just says what?
The direction to pay is essentially the same, but now if they don't get the full settlement from the insurance company, the homeowner is on the hook and that company can put a lien on the property.
Perfect. So that was a very surmised version. Dahlene, thank you. This has been a really good conversation. I think very informative. Melissa, as always, I appreciate you.
Of course.
And as we're going to end the show, I want to give a couple thanks to additional sponsors: Apex Performance Chiropractic, Claim Wizard, Public Adjusting CRM, and the Z Goalkeeper Academy. So if you have kids that play soccer and they're goalies, check out the Z Goalkeeper Academy website. And as always, come find us in WFLA Orlando. on the socials at www.boots-2-business.com. Daniel Rabowski, this has been Boots to Business. See y'all next week.